I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today is number 155 on our compilation list. We will be sitting in 2 courtrooms and we will be rubbernecking at 1 traffic stop. Before I give you the location of all of those, just know there will be chapters added for your convenience. Don't forget to like, comment, share, and subscribe. Some commentary will be left from these previous proceedings. And now let me give you the rundown of where we will be hanging out on today. First, we will be in the courtroom of Judge Lisa Martin out of the state of Michigan. Second, we will be in the courtroom of Judge Phyllis Webster out of the state of Kansas. And last but not least, we will be in Bastrop, Texas, rubbernecking for our traffic stop. Guys, we're at 155 and we're going to keep rolling on, and we're not going to let anything stop us. And listen, nothing else to do but to jump into 155.
Yes, sir.
Before you call the case you think I might be here on, I've had a chance to talk to Miss Seeley. She was in the MIDC waiting room, and I explained the charges to Miss Seeley. However, she would like to know under which jurisdiction I operate. I've explained that I'm a criminal defense attorney and I don't operate under any jurisdiction, so I don't think she's seeking the services of an attorney at this time, and the court may like to speak with her.
Thank you, Mr. Batar.
You're welcome, Judge.
These are 23HR0457A, B, and C. These are Huron Township versus Bonita Seeley. Ms. Seeley, were you able to hear Mr. Batar just now?
Oh, first of all, are we on the record?
Yes, ma'am.
Okay, are we under penalty and perjury?
Are we on what, ma'am?
Under penalty and perjury, is he willing to swear in?
I'm sorry, ma'am, I can barely hear you.
I said, is everybody willing to swear in under penalty and perjury?
Ma'am, we're not taking testimony as of yet. Today is the day and time scheduled for the pre-hearing and adjourned arraignment pretrial in these matters.
It still has to be placed on a record. He still has to be put under penalty and perjury because he's swearing to an alleged crime against it and holding me accountable. So even though this is just a hearing, it still has to be put on notice for the public as well.
Ma'am, today is the day and time scheduled for the pre-hearing and the arraignment pretrial. Would you state your name for the record, please?
Bonita Seeley.
Ms. Seeley, Mr. Batar is the court-appointed attorney assigned to this courtroom for the day. He's indicated that you don't wish to engage his services. Is that correct?
No, let me explain my position. I asked him a simple question about jurisdiction. That's why this hearing has been re-adjourned for today, because the last hearing, none of the attorneys could answer the question in regards to what jurisdiction that we're operating under. So they want to proceed without addressing the jurisdiction, which is a violation of due process. So in order for him to be represent me on any public record, I have to understand what jurisdictions he's operating on.
Ms. Seeley, if you do not wish to use the court-appointed attorney, and you confirm as much to the court right now, Mr. Batar can go back, ma'am. Mr. Batar can go back and do other things that he needs to do this morning. Do you wish to use Mr. Batar's services, or do you wish to represent yourself this morning, or do you wish to retain counsel through some other mechanism?
Under what charge, under which jurisdiction, and then who's bringing the charges against me?
Ma'am, there were citations issued against you in Huron Township for limited access speeding 11 to 15 miles per hour over the posted speed limit. That's a civil infraction. There's count 2, no proof of insurance, and there is the misdemeanor of driving while license not valid or improper license. Do you wish to use the services of the MIDC attorney, or do you wish to represent yourself this morning, or do you wish to retain counsel?
Who are the parties bringing this claim against me? It's a simple question. You're
I
trying to
answered your
avoid this
question, ma'am. I answered
Who's
your
bringing
question,
the
ma'am.
charge?
I answered your question, ma'am.
And could you re-answer it? Because I didn't hear it. Who's bringing the charges against me?
The citation that was issued to you was issued by an officer from Huron Township, Freddie Yono. It's the citation that was issued, is signed.
So it's Freddie.
It has his name and his ID number. Ma'am, my question to you is, do you wish to engage the services of the court-appointed attorney, or may I release him to go back to do some other work?
Wait a minute, I have questions before I can answer on. You're trying to get me to
No,
avoid
ma'am.
questions that you
No,
know.
ma'am.
Yes, it's a,
No, ma'am.
it's a due process violation. Objection. Yes.
Miss
Because you're not
Seeley,
hearing
this
me.
is
This
the
is a
Miss
hearing.
Seeley, this is the third and last time I'm asking you. Will you be using Mr. Batars to represent you this morning, or do you wish to retain your private attorney, or do you wish to represent yourself?
I need to understand what jurisdiction we're under.
Mr. Batar, you may return to your breakout rooms to meet with other potential clients. Thank you.
Thank you, Your Honor.
Your Honor, I
Miss Seeley, do you intend to represent? I'm sorry, Miss Foley Carter.
just want we started this case back in July. Ms. Seeley attended her first pretrial. She demanded that the case be dismissed. I declined. I asked that the case be set for a bench trial. Ms. Seeley objected, and Magistrate Hinman advised her to file a motion stating her objection. Since then, she asked Judge Green for her oath of office and then didn't appear for the court dates before Judge Oakley. So this case has been going on for quite some time with no resolution.
Because I'm asking a question and it requires a rebuttal when it's being ignored. You cannot violate the due process. This is a hearing, and any question that I have needs to be answered. You don't get to sit in the capacity of government and ignore the questions that the people have. Someone's bringing a claim against me, and my only question is, are we dealing in a commercial or a common law, also known as a record of law, court? That's simple. So are we in a common law court, yes or no?
Marianne, a trial, in-person bench trial date in this matter, please.
Objection. Objection. Are we in a common law court, yes or no?
January 23rd
Case dismissed.
at 11 o'clock.
Case dismissed. Case dismissed because you refuse to rebuttal to the question regarding jurisdiction. You cannot proceed without honoring the jurisdiction. You cannot be in
Ms.
the capacity
Seeley,
of a... Yes.
the misdemeanor matter and the two civil infractions that are traveling with it that were issued on April 26, 2023 will be set for an in-person bench trial in courtroom number 1.
Objection. I will not be showing up. Objection. I will not be showing up. You refuse to answer the question of jurisdiction. You're trying to get me into the courtroom so you can take me against my will and lock me up in a cage like an animal. Objection. You do not have jurisdiction over me. You do not have judicial authority in North America. You are working for a municipality called the state of Michigan. You have no jurisdiction. You are an attorney. You work for a corporation. You are in a municipal capacity. You have no authority. You call yourself government. Your position is a public servant.
Miss
I am the
Seeley,
objection.
Miss Seeley,
no, you cannot proceed as an attorney. Objection. I will not be showing up in court. I will appeal this matter. Objection.
There's no question pending to you, ma'am. This court will be muting you at this time because this court, the court has muted Ms. Seeley as her responses are not responsive to the matter that is before the court. This matter is being scheduled for trial. If Ms. Seeley wishes to absent herself from that trial, that is her absolute right. That trial date is January 23rd at 11 a.m. That concludes this matter.
Objection.
All right, we will go on the record now in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is case number 2023 TR3 00060, State of Kansas versus Isaiah S. Curvin. And the defendant, Isaiah Curvin, appears in person and pro se. This is the pretrial hearing. The trial is set for jury Wednesday and Thursday of this week. February 7 and 8, there is one count of operating a motor vehicle without a valid license. Now, that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license. But Mr. Curvin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before all that about the jurisdiction. I was challenging jurisdiction because I had a question about that.
Okay.
'Cause I wanted to know the cause and nature of what's bringing the suit against you. So I really didn't understand.
Okay. Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas that pass the laws through their elected representatives. And they also pass laws to have judges, and I'm one of those judges that presides over these type of cases. They also pass the law that you can't have a jury trial for this type of offense. And so that's the authority, that's the nature of it. It's a traffic case, but it's also designated a criminal case, a B misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would that it gives the court two ways? Sixth Amendment actually gives the court two ways to do it. They can do it through either common law or is it callable maritime admiralty law? Which one am I want to be tried under with jurisdiction?
This is neither common law nor admiralty law. This is criminal law under the Constitution of the state of Kansas, as affected by case law and federal law, of course.
So it's neither common nor color.
That is correct. That is correct.
So which one? What am I going to be tried under? What jurisdiction I fall under so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
But under the Constitution, it grants you only two, and it has two criminal matters. One has to be common law, the other has to be the maritime admiralty.
Ms. Gillette, do you wish to be heard in response? I'm sorry, I didn't mean to cut you out.
Basically kind of more of a statutory violation. This defendant, when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states that are members of the interstate compact for traffic infractions means that when you consent to the laws of your state or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter into that state. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas. and the laws of the legislature that are passed statutorily, and our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well, that's
Therefore,
because I'm just asking questions right now.
if he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench trial.
Miss Gillette, we just had this exact issue on not filing a demand for jury trial in a Butler County case right before the lunch hour. Mr. Patterson presented 19 Canap 2nd 982, State of Kansas versus Gardner L. Jones III. Jones raised two issues on appeal: whether the district court abused its discretion by denying his request for jury trial, and whether the district court erred in denying his motion for setting an appeal bond. Well, I have not had time to read that case over the lunch hour, which began at 1 o'clock today because we ran so late this morning. But Mr. Patterson, as an office of the court, informs me that in a case like this, even though the statute of Kansas is very clear that you are to put your demand for jury trial in writing, the case law says you don't have to because of your constitutional right.
I haven't had time to research it or read it, Judge. I don't have any kind of written request or motions, and I would have to take time to also read the case.
Sure.
And see if it's distinguished, if there's different issues. But he's wanting to argue jurisdiction, dismissal motions, and all kinds of motions. There's nothing before the court in writing for me to respond to. I don't know what he's going to say. So one of our other pro se individuals had written several motions. Most were very lacking, but at least I had something to respond to. In this case, under the laws and Constitution of Kansas, you submit when you come into our jurisdiction. Therefore, when he traveled into Kansas and operated a motor vehicle, he consented to the laws and jurisdiction of Kansas. And I would say that we have jurisdiction, and that lack of venue and jurisdiction is denied, should be denied.
I had a question about that, because when you say that I consent, is there like a form? Would that be under? That would be civil? Would
Sir,
that be
you consented by your conduct of going onto a road that is a state of Kansas highway and a.
So which jurisdiction would be under? Like, would that be like maritime, like as a
Sir,
contract?
I've answered that question to you, and you got on the road and you consented to driving on the road, and therefore you did consent to laws associated with driving. So I am going to hold you to the law in this particular case. Now,
what I'm understanding, when you say the cause of nature, and but that's why I was not understanding still about that, because you said the cause of nature, and I asked.
Sir, if you want me to entertain any of your arguments, you need to have them well thought out, and you need to have them
That's
in
what happened.
writing, and
That's
you
what the
need to have them,
appearance for.
sir, listen to me, please. You need to have them in writing. You need to have them filed with the court. You need to give copies and notice to Miss Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and you just start saying things.
I have a question.
Things
That's
that you
why
may have picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff that so far I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to have to give me something that tells me I have to follow those arguments, because I think you're misstating the law. So by now you should have had all your motions on file. We're ready.
Maybe misunderstood what I was
asking. Please
asking.
don't interrupt to me.
I had a question.
Sir, stop and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to represent, sir, stop interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing, and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law. And if you don't have the benefit of knowing the law, you're going to be disadvantaged.
Well, before I move forward, I had questions before I move forward. That's why I was asking to understand it. I often understand this.
Well, I can't aid you in the unauthorized practice of law. I cannot.
No, I'm not asking for legal advice. I'm asking for your legal intent. What do you intend to be trying me with jurisdiction? That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal, sir, there's someone's been hurt. So if there's someone's been hurt, I have the right to cross-examine.
I have answered your question legally, and you keep trying to give me limited illegal choices, and I'm not going to do that.
Under the Sixth Amendment, I have the right to know. Under the Sixth Amendment, I have the right to know what jury I'm going to be tried against, and you have the duty to tell me. I don't think you're going to be violating your oath to office if you did that. I've
answered those questions, sir. We need to move on. I've made it clear to you, it's a couple of hearings now, that you're being tried in the District Court of Greenwood County, Kansas, under the laws of the state of Kansas. And we're not going to keep running in circles on this.
That is not.
You know this, and I know this, and I feel like you're just kind of.
No, what I'm asking, so the court the Constitution only grants the court under when it comes to criminal under two matters, and that's why I asked you: is it civil? Is it civil or is it criminal? What you said is criminal, you said it's not civil, right?
Sir, you can reserve your right for appeal, but I have ruled. Now, what's your next question or your next point of view? I need to have you back here. Bring your camera back so I can see you.
Your phone froze. I didn't hear what you said. Your phone froze. It froze.
I don't know if my phone froze or your did.
Oh, my phone froze. You cut out for a second.
Okay, so do you want an attorney? I'll ask you that again.
Before I get to that, I still have to find out. I have the Sixth Amendment right to know. To if I ask, I have the right to know. I'm not asking for legal advice. I'm asking for your legal intent.
Do you want a jury trial and do you want a lawyer? Those are the two things.
Before I get to that, I have to understand what jurisdiction I'm under so I can rightfully, know how to defend myself.
Okay, now. You don't like my ruling.
You don't. So are you telling me I have to get a lawyer to understand? For the record, you just have to get a lawyer to find out what I'm going to be tried against? Is that just some type of secret jurisdiction that I shouldn't know about?
Okay, sir. Here's the deal. I'm not going to play games with you. I understand the right to defend myself. The sovereign citizen position that you
I'm not
take.
claiming. I didn't say anything about sovereign anything, ma'am. I'm
Well,
asking
you're
have the
sure
right to
making
defend
their
myself.
arguments. You're sure
Under my Sixth Amendment right to know, I have right to know which jurisdiction are you going to try me under, and you're telling me in order to ask me for a lawyer, and I'm like before I even go to trial, I like to know what jurisdiction am I falling up under, and you're telling me I have to find in order to find out I have to get a lawyer. So you're telling me for the record, the defendant has to get a lawyer because there's already some way only lawyers understand what jurisdiction or whatever I'm going to be tried under. So that's the only way I can know. Instead of you asking me, but you have the duty to tell me under the Sixth Amendment, do you not?
Okay, now it's your turn to stop talking and my turn to talk. I have answered your questions. I've told you the jurisdiction. You don't like my answers, so you voice your objection for appeal and we move on. We're not going to keep playing this game, sir. Now, do you want a lawyer or do you not?
I need a lawyer for you to tell me. When I'm asking you, like, because you saying it's not in the criminal matter, so there's a hurt party.
Sir, quit repeating yourself.
If there's a hurt party, can you present the hurt party to me?
If you keep sitting here wanting to argue with the court, I may have to find you in contempt. Is that what you're trying to get me?
I'm not arguing about the court. I'm trying to understand.
I cannot educate you and train you.
I'm not asking for education.
If you want to sir, do you know there's a person that's going to try to type out this transcript? And if you keep talking over me, do you know what chaos you're going to cause for that transcriptionist? We have to take turns talking. I've answered your question repeatedly. Let's move on to the next question. Or the next point. You don't have any motions I can rule on because you don't have anything in the file. So are you going to hire an attorney, apply for court appointed, or continue on your waiver?
So if you're going to try, is there someone that was hurt to make a criminal matter? I'd like to know who it was.
Are you going to hire an attorney, apply for court appointed, or continue to waive your right and represent yourself? Keeping in mind, sir, if you waive your right to an attorney, you will be held to the same standards as a defendant with an attorney. You will be held to the same standards as the attorney. You need to know the same rules, procedures, and laws. So what are you going to do on the issue of attorney? Continue to.
I'm just simply asking you to identify which the code of the written law that you're asking to do. I'm just asking you to which code is that you're bringing against me as constitutional law. Because if that's a similar law.
Taking up time. Can you not understand what I'm saying?
You're asking me if I want a lawyer. If I want a lawyer, I'm not moving forward because I'm not understanding where we're still going under here. Where you're telling me like it's on the criminal matter. If it's on the criminal, if it makes a criminal matter, that means it has to be like some injured party. Where is injured party at?
I'm going to order that you appear at the courthouse. Where are you parked right now?
I'm in Texas.
You do know your trial is Wednesday and you have to physically be present in the courthouse. It is not a Zoom.
Before we get to trial, I'm trying to figure out the jurisdiction. You just haven't went over to me what the jurisdiction is.
Well, if you don't want to submit to the Kansas jurisdiction for your live trial on Wednesday, I can get you a warrant and you can be brought before the court.
Yes, I'm appearing in person right now. I'm doing my duty to appear, but you're not telling me.
We're not having a Zoom jury trial.
They're not telling me. You're not telling me you're not even telling me what the nature of the cause. You're not even telling me if it's common law. If it's common law, then you're telling me that it's a criminal. If it's criminal, then there should be an injured party. I'm asking where's the injured party? Can you bring the injured party forward?
I am going to, Missy, do you know where Miss Gillette went?
I don't, Judge. I'm assuming she lost signal.
So, are you not going to tell me this what today? You have the right to know.
Do you want to try to see if you can find her for me, Missy?
I think when she gets signal, she'll be back.
Okay, well, we're going to be in recess till Miss Gillette gets her signal and gets back here because I'm not going to do anything without both parties present. So we're going to go into recess.
Sorry, Judge, my phone screwed up.
Well, apparently the defendants did too, so I'm gonna give him a few minutes to see if he comes back.
Everything went out and I couldn't get back on at all.
There he is. We are back on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Case 2023 TR 300060. State of Kansas versus Isaiah S. Curvin. Parties as before. Mr. Curvin, you are set for jury trial.
But before we even get to trial, man, you still haven't answered my questions. But I still want to know
Wednesday,
the cause of nature of the
Sir,
matter.
I'm going to find you in contempt if you keep talking over me and being disrespectful.
Ma'am, you keep not even answering my question before we
All
get to jury
right,
trial. You're just
okay.
setting it.
You are now found in contempt.
Contempt.
We will deal with your consequences Wednesday at the jury trial. This is set for jury trial. It's going to cost the taxpayers some money, so you better make sure you're ready to go to jury trial come Wednesday. You better make sure you're not in Texas. You better make sure you're sitting in the courtroom in Greenwood County, Kansas. That's Eureka, Kansas. Do you understand, sir? Any questions about?
I don't know. I still have questions that was never answered.
I'm not your attorney, sir. I'm your judge.
Yeah, I know you're not my attorney. I'm asking you, Judge, what is your I'm asking for legal violation. I asked you what was your legal intent. You still haven't told me what your legal intent. I asked you what was the nature and cause of this.
My legal intent is to conduct a jury trial on you Wednesday with the jury.
And what was the nature and cause of this whole before all that?
The nature of this charge is that you were allegedly operating a motor vehicle without a license in Greenwood County, Kansas, November 9th, 2023. That's the nature. Now,
and you said this, and I asked.
We're not doing this.
I said a question. So when I asked you what jurisdiction, the Constitution grants the courts the two jurisdictions. Which one is common law, and the other one is maritime admiralty law. You said it's neither one of them.
Sir, you better go back to law school because I don't think you got the education you need to represent yourself. You go back to law school or go to law school or get an attorney, sir, because you don't understand that which you're speaking of. So be ready to go. And if you're not here and ready to go, Wednesday, I will issue a warrant for your arrest.
Your Honor, I still have a question. You still haven't answered my question before you dismiss. I asked you which law
sir, I am not
under the Sixth Amendment, right? Under the Sixth Amendment, you have the
okay, I'm gonna fine you. I'm only gonna fine you $50 for that first contempt.
$50 for what?
For continuing to ask the same questions over and over after.
I'm asking it. You never answered it. You never told me.
I'm going to object. It's been asked and answered. It's been ruled on, Judge. We need to proceed to the next step. The state has taken the opportunity to glance through the case Mr. Patterson cited. It can be distinguished from this case because the ruling says the person has to be subjected to up to 12 months imprisonment. It is a DUI case. Where someone was convicted of a first-time DUI and they were subject to 12 months of prison time or jail time under the law. This is a Class B non-person misdemeanor that's 6 months or less. It must be greater than 6 months in order for the person to be subject to an automatic jury trial. Otherwise, lacking the request, it may be a trial to the bench. Under the case law. So therefore the state v. Jones did not apply in this matter. He is facing no more than up to 6 months. So the automatic requirement for jury trial does not apply in this case to Mr. Curvin. The request for jury trial would still need to be in writing for a matter that's up to 6 months. And therefore, I would ask that we don't waste a jury's time and have a bench trial on Wednesday and move forward in the case.
Mr. Curvin, do you want a jury trial or a bench trial?
I want a jury trial.
Understand, I'm not going to prejudge, but strike. Ms. Gillette, can I continue this for further pretrial hearing with the live hearing, defendant present tomorrow at, what do you have? Can you fit me in at what, 2:30, Missy? Do you have time then? Pick me a time. Give me about a half an hour tomorrow that you can fit me
I
in.
think our 11 o'clock went off. Let me.
I was going to say
Are you saying I have
11 o'clock is the perfect time for the state, Judge.
Well, but I've got
So
to
you gonna
give
have to be
Mr.
in court
Curvin,
tomorrow?
I've
got a
got to give, sir, please quit interrupting. This is not a free-for-all. Miss Gillette, we've got to give him time to drive up from Texas.
Yeah.
Well, if he doesn't have a license, he can't drive. We have to give him time to find someone who can drive him up here, or give him time for a plane ticket, or however he wants to get here.
1 o'clock p.m. from 1 to 1:30. Then we can start the first appearance docket at 1:30.
Sounds good. Okay. Sir, this is going to be a live pretrial hearing tomorrow at 1 p.m. You must be
I cannot
present.
make it tomorrow, ma'am. I'm in Texas. That's what I was trying to tell you from before.
Well,
You told me you said Wednesday at first, and now you're saying tomorrow.
well, your jury trial is Wednesday. Your pretrial is continued to 1 p.m. tomorrow. There is no law that says I have to give you a Zoom hearing. I try to do that as a courtesy. In
I
most
could do the
cases,
Zoom, but I wasn't able to drive because this like where I'm at, like I'm already like right here by San Antonio. It's like about a 14-hour drive. Like even if I like drove right now, I would still wouldn't make it to like probably 2, and I would like drive like this like 32, 14. That's like half the day driving. Now I don't have nobody to drive like that. You know, man. Like that's why like
if you don't have
I
a
wouldn't.
license, you better not be driving, because then that'll be another violation of the law. But that's my order. Be here at 1 o'clock tomorrow, live and in person. If you're not here, then most likely a warrant would issue for your arrest, and we'd go from there.
Well, I'm telling you, if I wouldn't make it, what's my other option? If I'm already in Texas, not to, 'cause that's hours away. You know, it's like about 4 different states.
Well, sir, you came to Kansas, you violated the laws allegedly in Kansas, and you've taken up a lot of the court and counsel's time. So,
Well, I was told the officer said he told me I can take care of it from Texas. I will have to come back to Kansas when I see the
I have
ticket.
always told you that the trial would be live. Don't be pulling that on
No,
me.
no, not you. I'm talking the officer when I got the ticket when I first got it. I let him know like I was just coming through Kansas. Like you don't live here. He said normally it's to do video and stuff because it's like different state.
Normally it is, but I'm ordering that you be here in person tomorrow at 1 o'clock. And anything further, Miss Gillette?
Nothing at this time.
Hold on, my phone cut out. Hold on. So,
Mr. Curvin,
say that again, ma'am.
any motions you want to take up tomorrow at the pretrial, you better have them filed by 5 o'clock tonight with copies served on the prosecutor, or I'm not going to entertain them tomorrow. You've had a long time to get those on file, and you haven't done it. And I'm through with repeating myself over and over. So at this time, you owe the court $50 for contempt. We'll address that tomorrow as well. Okay, we'll begin recess.
When I have a question before we go, when you said like how to file the motions and everything, did you receive my special appearance motion and anything like that?
Nope. No, sir.
You hadn't received it from last time?
Nope.
I filed that before.
No, sir. I don't know what you're doing with them, but we're not getting them here.
I was told that you had received them through email, or I sent the email to a few times. Not like that was the only way.
If you can't figure out how to do it on your own, then you need an attorney. And I have told you repeatedly that if you cannot afford an attorney, you can apply, and I will appoint one.
They told me they had received them before. That's why I was understanding. Like you say you never received them, but you say you received them before. Like the first time we appeared, and then I haven't received them. I haven't called.
Just because you keep repeating something doesn't mean you're going to get a different result.
No, I haven't repeated. I'm asking like they never received it, but they told me they did. That's just
you keep saying the things over and over, thinking like you're going to get a different result, and the answer is going to be the same every time.
You have a good day, Your Honor.
Thank you, sir. We are adjourned.
Thank you, Judge.
Well, guys, we have come to the end of our proceeding, and by the looks of this one, it's only going to get crazier. Man, this was, I don't know about for you guys, but this was an exhausting proceeding to be a part of. It definitely seems like it was exhausting to the attorney, the prosecutor, and also to Judge Webster. I mean, man, Mr. Isaiah, man, if you want to look in the dictionary under the definition of repeat, his picture would definitely be there, because, man, he repeated the same thing over and over and over again. That was insane. Jurisdiction, am I being tried under common law or admiralty law? And then she told him, no, you're being tried under criminal law. And then she told him, listen, your motions need to be well thought out. They need to be in writing. But yet he just kept going on and on and on, to the point of where eventually Judge Webster said, listen, I had enough. She finds him in contempt of court. And if you notice, when she said to him, like, listen, this pre-trial is going to be a live trial and I want the defendant present, it seemed like all of a sudden his understanding was 100% there, because he understood that right away. He addressed that right away. Everything else he had been talking to her about and she had been saying to him, it was like he didn't understand anything. But when he heard her say that, immediately he was like, wait, are you saying that I have to be in court tomorrow? She was like, absolutely. So this is going to be interesting to see how this all plays out. I'm telling you guys, we're going to be sharing these next two proceedings the next 2 days. So stick with us, because I think, I haven't seen the other two proceedings yet, but I think that this is going to be definitely a crazy rest of the way, just by looking at my man's behavior. And not only that, he's sitting in the car doing his court meeting, and it's like nobody's saying nothing, nobody's asking questions. Judge Webster's like, oh, you better not drive here. Well, it looks like he's driving now, Judge. So it's going to be interesting. But with that being said, I'm gonna stop talking, guys. Once again, as always, this is Sovereign Citizens Hall of Fame. I appreciate you guys for joining me. God bless you guys. And for now, Sovereign Citizens Court is adjourned. See you on tomorrow.
Hello, sir. Deputy.
What's your emergency?
What's the emergency? Well, you were using the shoulder to travel there, sir. I'm Deputy Ryder of Bastrop County. The reason we're pulling you over is you're traveling the shoulder there. You have your license?
Why do I need a license?
To drive this vehicle.
Am I driving a vehicle?
Yes, sir, you are.
I'm driving a vehicle.
Yeah, you're operating a motor vehicle.
This is an auto.
You need a driver's license to operate a motor vehicle.
Okay. All right.
All right. So do you have a driver's license?
Is this a... Go ahead and hop out.
You committed a traffic offense.
I am not getting out of my vehicle.
Go ahead. Yes, you are.
No, I'm not.
Yes, you are.
I'm talking to this guy here.
Okay, I'm the one in charge here.
Okay.
Hop out of the
Are you
vehicle.
a sergeant?
I'm his supervisor. Hop out of the vehicle. Go ahead and hop out of the vehicle. Okay. The Supreme Court of the United States says you will hop out of the vehiile if you were given a lawful order. Hop out of the vehicle.
Is this an arrest?
You are being detained.
All right,
you need to stop. Listen to your wife.
No.
Hop out of the vehicle. Okay, listen.
If I'm going to be detained.
We're giving you a lawful order to exit the vehicle.
All right. So you're telling me I'm going to be detained, right?
You are already detained.
Okay, so I'm a custodial too? So I'm not going to give you any information?
Hop out. Okay, then hop out. Hop out. Okay.
My property.
Hop out of the vehicle. We are giving you a lawful order. Okay, we're not playing this game.
I give you my name, and then give me the ticket.
We are not playing this game. You're failing to identify. Exit the vehicle. You're following.
I'm not failing to identify.
Also.
You didn't ask me for my name.
Okay, hop out of the vehicle. I'm giving you a lawful order to hop out of the vehicle. Okay, do you want to play this game, really?
Do you want to go to court?
Yeah, I'll go to court. I'm happy to go to court. I get paid to go to court. Hop out of the vehicle now. Okay, go ahead and pull him out.
I do not.
Go ahead and pull him out.
Yep.
1623. We got one.
I give you my name.
Sir, just go ahead and remove your seatbelt and step out. This is a lawful detention.
All right, but I'm not giving you any information.
Huh? Just step out to the back of the vehicle here.
All right, I'm going to get my phone.
That's fine.
I have my information in it.
Stop back here.
This right here is good.
Do you want to provide your ID yet?
Do you ask for my name?
Do you want to provide your ID?
I don't have to give you ID.
521.025 says If I request your license, you have to submit it on demand.
Right.
That is Texas Transportation Code 525.02.
You said custodial arrest, right?
You are being detained at this time.
Custodial arrest, and I'm not giving you any information.
Okay, go ahead. Go ahead and.
I'll give you my name.
You're going to jail for driving on an improved shoulder. Okay? Put your hands on.
Okay, I'll give you my name.
Put your hands on the car.
Sorry, I'll give you my name.
Put your hands on the car.
All right, I'll give you my name.
Put your hands on the car. Put your hands on the car.
I'll give you my ID.
Put your hands on the car. It's too late for this.
Go ahead and set your phone down on the bumper there.
Can I take my phone with me?
Okay, now you're being arrested. You're being arrested for driving on that improved shoulder. You understand? So now you're under arrest. So now if you fail to provide your ID, I'm going to add an additional charge.
I don't have any weapons on me.
It doesn't matter. If you're under arrest, he can search you. Okay? Do you want to provide your ID now, or do you want another charge?
I'll give you my ID.
Okay, where's your ID at?
In my wallet. This is the other end.
Okay.
Ma'am, you have an ID. He is now going to jail.
All right, come on, step back to the vehicle this way. I'm going to get your phone.
We'll get your phone.
Step here by the rear
You
wheel.
made a simple traffic stop into an arrest.
No, you guys made it.
You did.
You guys did. This is unlawful.
Can you unlock it?
This is not unlawful.
It's illegal.
Hey,
All right, step up in here.
Look at me.
No, I'm not going to argue with anyone. I'm going to take her to court.
Okay, go ahead and take us to court because the U.S. Supreme Court gives us the authorization
You can
to
step
pull you
up
out
in
of
the
your
vehicle.
vehicle if we give you a lawful order. Does he have a license?
Yeah, he does.
Okay, wait a minute.
What happened?
My arm.
Here, go ahead and step out again.
Okay. I'm not going to harm you guys.
No, you're good. Step out of there.
Ow.
Did they tighten up on it?
Oh, yeah, they did.
Right.
Oh, my God. I'm not going to harm you guys.
You need a second set?
No. I just didn't know how yours double locked.
Mine double lock with these little flips. Right there.
This one makes it tight.
Here, let's put a double set on them.
Yep.
I'm not going to harm you guys. Seriously.
Listen, we're past that point, okay? We were trying to do a simple traffic stop. You turned it into something. Go ahead. Listen, look, turn around. I'm gonna explain something. Turn around. Okay. You know what? Fine.
I'm not gonna do it.
You might want to look at what the Supreme Court says. Okay.
Oh, I am.
Okay.
I already have.
Well, apparently you're wrong because the Supreme Court says if I give you a lawful order to exit your vehicle, you exit.
Sorry, I'm not gonna.
Right, you can go ahead and sit back up in there.
Thank you for being. I do appreciate your jobs, guys. Thank you for being so nice.
Yep.
You have any other questions?
So just call bail bonds, man.
Yep. Well, he'll be able to call you here in about an hour. He'll be able to tell you what he's getting charged with. So right now he's going to jail.
1633, 27 for the detained.
Okay. After he was
066000591.
Two videos correct. But the part that's incorrect is if we ask for an officer safety reason, and that's an officer safety reason, him not identifying, and him saying he's not a custodial stop, we have every right to pull him out of the vehicle, and we can pull him out forcefully. The Supreme Court of the United States says we can. Okay, and that's in all 50 states. So, right now he's just getting a simple Class C. Okay, and that's it. He's going to jail for driving on an improved shoulder, and that's it. Okay, so could have all been avoided. All he had to do was get his license, provide proof of insurance, and he would have got a ticket at most. He might have even got a warning. Okay, so I mean. But at this point, he's going to jail. Okay. You got any other questions? Like I say, he'll be able to call you here probably. It'll probably take him 45 minutes to an hour to get booked in, and then he'll be able to make a phone call. Does he have your phone number?
Yes.
Okay. All right.
Thank you, guys.
You're welcome.
Did you grab his phone?
Yeah, I got his phone in his wallet.
Okay.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.